My name is Stephen Levinson. My number is 2661.
Thank you.
I speak in strong support of SB 1. I've submitted written testimony. I'm not going to repeat it. I was intending to speak to a particular matter, but the subject of legislative intent in the context of the 1998 constitutional amendment has obviously come to the fore and is a matter of great interest to the committees, and I am happy to speak to that subject if the committees would like me to and answer any questions.
As long as your testimony is within 2 minutes.
All right. The proposed constitutional amendment was contained in House Bill 117, the 1997 legislative session. Section 1 of HB 117 sets out the legislature's intent regarding the constitutional amendment clearly and unambiguously. As a bit of background, courts are called upon all the time to determine legislative intent. The rules of statutory construction provide that if the legislation is clear and unambiguous, it expresses the legislature's intent without the need to look to anything extrinsic, and in fact looking to anything extrinsic becomes inappropriate. In the face of ambiguity, the courts first look to any express statements of legislative intent that there may be. If there are none, courts then look to legislative committee reports to reflect the intent of the legislature. If intent is not reflected there, courts look elsewhere, including to the remarks of individual members from the floor, which
Thank you, Justice Levinson.
all right. Again, I'm available to answer questions later if anyone wants to ask them.
Thank you. Okay, next up, the members. Any questions? Oh, Representative McDermott.
Justice Levinson, can you come up, sir? Thank you, sir, for being here, and thank you for your service to our state.
Thank you, Representative.
You are a formidable and brilliant legal mind, and it's with great trepidation that I even ask you a question.
No need for trepidation.
Be kind. My first question would be the recent Supreme Court decisions. We've been, as a matter of fact, when the governor came down to the minority caucus, he said to us, because of the recent Supreme Court decisions, we've got to have a special session. I'm paraphrasing, of course, but that was the big thing. And so the people out there, the truck driver, the clerk at Long's, the one who only reads the headline, DOMA struck down, and go back to work, busy raising kids and their families. That's all they read. Did the United States Supreme Court, in either of the two decisions, specifically enumerate a constitutional right for same-sex marriage for citizens across the United States?
No.
Okay. I would like to ask you, in the Baird decision, the conflict between the 14th and First Amendments, was that ever addressed?
No.
Okay, very good. This is quick. I expected much more than that. Okay. One of the questions I asked yesterday was the Department of Education. And you were a judge, so you still are, you're retired. If we pass same-sex marriage, and the Dick and Jane books, and I'm using that because both you and I are a little long in the tooth, the Dick and Jane books that we grew up with, they have different names now, but they have a mom and a dad, and et cetera, et cetera. If a homosexual couple, after this is passed and becomes law of the land, brings a lawsuit and says, hey, there are no homosexual couples represented in any of the curriculum, in any of the materials, my child feels like a second-class citizen. Is that in the realm of possibility?
I'm not sure what you're asking, Representative McDermott. If you're are you asking me whether it's within the realm of possibility that some
okay.
parent might have that feeling.
Okay, let me be more succinct. If we don't put in our books representations of homosexual couples, like in the Dick and Jane books, like they're doing in California, I'm sure you're aware of what's going on there, are we creating an environment of intolerance and inequality if we do not take affirmative action to show those representations?
Well, my gut reaction is that that's a complicated question, but I don't think the marriage equality bill is germane to it.
Well, it would be germane in the sense, and of course, you're a brilliant legal mind now. It would be germane in the sense that it is now the law of the land, correct? And once it's the law of the land, such things as a subordinate policy do no longer have the precedence. The law of the land trumps a DOE policy. Isn't that correct?
I don't know how to answer that question.
Okay, fair enough. Okay, do you believe, sir, that same-sex marriage is a civil right?
Yes, I do.
Okay. And can you explain the concept of a civil right to me?
That is a term that has specific legal meaning. It also has a generally understood meaning.
Reader's Digest so I can understand.
If a right is regarded as fundamental, it's generally perceived to be a civil right. So the right to marry has been recognized for a very long time as a civil right. Right to equal protection of the laws has long been regarded as a civil right. Increasingly, access to the status of marriage by same-sex couples is regarded as a civil right.
Okay, fair enough. So in here, we all have a civil right to free speech, correct?
Correct.
Okay. So if, in your mind, you said marriage is a civil right. So I am enfranchised with a civil right if we pass this law for a same-sex marriage. I'm enfranchised. He's enfranchised. Miss Carroll, who was here, was also franchised.
Well, I'd put it a little bit differently. The way I'd put it would be that with the passage of SB 1, the state would recognize a same-sex couple's prerogative and entitlement to have access to the legal status of marriage. I don't know how that computes with respect to enfranchisement.
Okay, well, we all possess the civil right, is my point. So why, if I'm in a relationship with Richard, no offense, and Melanie, no offense, and we are together in a familial relationship, and we want to formalize that so we have access to health care in a spousal situation, so we have access to retirement planning, so we have access to benefits, why should I be denied the right to visit one of my loving partners who I'm married to in the hospital? Why can I not exercise a right to marry Richard and Melanie at the same time? What is the moral reason I can't do that, or the legal reason?
Well, I don't have an answer for you with respect to moral reasons. You can't do that at the moment because the state of Hawaii doesn't permit you to.
Okay, fair enough. Lastly, in 1997, I was here, and you are a trailblazer, sir, so I tip my hat to you. Justice Moon came and gave his, I think it was either the first or second State of the Judiciary speech.
I was there, too.
Okay, good. And he told us somewhat cryptically, but he told us, and this was in the throes of all this controversy. He said, and I'm paraphrasing because it's been a long time and I don't remember the exact words, but Representative Ward was there and he might be able to chime in. At the end of the day, the legislature has the trump card to solve these controversies. and that is the constitutional amendment. And do you recall that?
I do.
Okay. Thank you, sir, for being so kind with your time. I'm very grateful for you, sir, and thank you for not beating me up.
Representative Johansson.
Thank you, Chair, and thank you for being here, Justice Levinson. We spent a great deal of time as a committee yesterday talking to the Attorney General, and much of a resonant theme that came up is what the judiciary might or might not do, and so I think it's helpful to have a Supreme Court justice also be able to chime in. And my question will be a bit similar to what I asked the Attorney General yesterday, and it has to do with a section in the bill that pertains to religious exemptions, allowing a refusal to solemnize being predicated on what does or does not constitute profit for religious organizations. And it stems specifically from page 6, lines 14 through 18, where the present bill explicates certain conditions that don't constitute a profit. And what I wanted to ask you as a former Supreme Court justice is, when you have a law that explicates some conditions that, in this case, do not constitute the for-profit, which is the precursor to defining whether or not there is an exemption or the ability to refuse to solemnize, what happens if some conditions are not explicated, where this bill may be silent on some other conditions that a religious organization or situations they may be involved in that might or might not be for profit? If you could just elaborate what the...
Representative Johansson, bear in mind that I don't have the bill in front of me. I have a general understanding or impression of the language that you're referring to, but I don't have it in front of me. What I think you're getting at is whether a list that appears in legislation is viewed as exclusive or non-exclusive. Is that the general ballpark?
Yeah, that is correct. Thank you.
As a general proposition, if the legislation states that what is listed is without limitation, then it is not an exclusive list, and items that are not included within it may be intended to be part of the purview of the general language of the legislation. Some enumerated lists are regarded as exclusive, and anything not appearing in it is not included.
Thank you for that.
Okay.
Thank you, Chair.
Thank you. Representative Fale.
Thank you, Madam Chair. Justice Levinson, I just have a couple quick questions. Just kind of going back to what the representative from EVA was talking about. So, in your interpretation, does the legislature have the power to define marriage any way it likes? Does the legislature have the power to define marriage any way it likes, whether it is the situation where he described, where he could be married to me and to another person? Can the legislature do that?
To me, it's fairly clear that Article 1, Section 23 of the Hawaii Constitution grants the legislature a monopoly under the state constitution in determining the parameters of marriage.
Okay. Thank you, sir. The next question is, and this is, I'm an individual of Tongan ancestry. I grew up as a little kid in the Kingdom of Tonga, which used Kamehameha III's constitution as the basis for the constitution that I was raised under. And in the audience here, and a number of members who have testified who are, Tahitian, Tongan, Fijian, Samoan ancestry. And I posed this question to the governor about whether, if Hawaii was still a kingdom, would it be more similar to its Polynesian cousins who per capita have a larger gay community than any other place in the world, and these communities have a longer history with the gay community than the United States has been a country. And yet, even within those cultures, and in any nation where the indigenous people are in control of their government other than Western Europe, have defined marriage between a man and a woman. My question to you, Justice, is there anything legally, morally, ethically, or governmentally inferior for these governments because they have limited marriage between a man and woman? Are they inferior in any way to governments or places that have decided to legalize same-sex marriage in their nations?
Representative Foley, I don't really feel equipped to speak to the superiority or inferiority of one government as opposed to another.
So, well, if a society decides to keep marriage between one man and one woman, is there, such as the rest of the Pacific Island nations, which have decided to do so, except for New Zealand, which former colony of Europe, is there anything wrong with a society that says that marriage is between one man and one woman?
I'm at something of a loss to answer your question because I don't think I understand it. I don't understand the question. I mean, that is a definition that would exclude same-sex couples. I mean, that's one thing you could say about it. Okay. You could say other things, too.
Well, the reason why I asked that question is that for a person who grew up as a little kid in the only nation that was never colonized by a foreign power in the Pacific, that even though military colonization ceased a number of years ago, that we continue to see, especially for indigenous people, a perpetual economic and cultural colonization of those communities. And just as some nations have cut assistance or types of communication with those nations that have a cultural difference, an example is between New Zealand and Tonga now because of some differences that are there. My concern there, and that's where it rises from, is that are there issues, because this is going to have wide repercussions, and for some to say that, and in the governor's words, for those who oppose this, you are unenlightened. And my concern is that this is a further wedge that will continue to divide and cause problems for the community. And does pushing this issue to say that if you're a community or a society that does not accept same-sex marriage, there's something morally, legally, or ethically wrong with you. And for being in the Pacific, I see that causing a number of problems given the diversity of the state of Hawaii. Are my concerns there valid? I mean, are there?
I think this is kind of a losing battle here because I
okay.
I just don't really feel like I'm the right person to give you a metaphysical answer.
Okay. Thank you, Chair.
Thank you, Representative Morikawa.
Thank you, Chair. Justice Levinson, thank you for being here. I enjoy listening and reading your testimony. There's a huge outcry to put this out to a vote. Do you have an opinion on why or why not that should be done?
Thank you. I do. And that relates to what I was trying to get into in my 2 minutes. Because there had been a lot of questions posed of earlier testifiers, and especially Senator Sakamoto, regarding what the legislature intended when it proposed the 1998 constitutional amendment that became Article 1, Section 23 of the Hawaii Constitution. And I think the answer to that question goes directly to what you're trying to get at, Representative. The amendment was proposed in a House bill in 1997 The House bill was House Bill number 117. It consisted of two sections. The first section of the bill set out the legislature's express intention regarding why it was proposing an amendment to the Hawaii Constitution. The second section set out the language of the proposed amendment, which became, the legislature shall have the power to reserve marriage to opposite-sex couples, and that became codified at Article 1, Section 23 of the Hawaii Constitution. In explaining why it was proposing the amendment, the legislature said three things. The first thing it said was, quote, the legislature finds that the unique social institution of marriage involving the legal relationship of matrimony between a man and a woman is a protected relationship of fundamental and unequaled importance to the state, the nation, and society. That's number one. So the legislature proposed the amendment in part because it found that the marital relationship between a man and a woman was very important. Two, quote, the legislature further finds that the question of whether or not the state should issue marriage licenses to couples of the same sex is a fundamental policy issue to be decided by the elected representatives of the people, unquote. So the clear meaning, unambiguous meaning of proposition number 2 is that because this issue is so important, the people's representatives, the legislature, should decide the question as a matter of fundamental policy. 3, quote, this constitutional measure is thus designed to confirm that the legislature has the power to reserve marriage to opposite-sex couples and to ensure that the legislature will remain open to the petitions of those who seek a change in the marriage laws, and that such petitioners can be considered on an equal basis with those who oppose a change in our current marriage statutes, unquote. And so proposition number 3 was that the legislature expressly, clearly, and unambiguously intended that the question of same-sex marriage would remain open, and that the legislature would remain open to a change of policy position in the future, depending on future circumstances. All of that is clear and unambiguous. The question is important. It's to be decided by the legislature, and the legislature is open to change. Now, when courts are asked to discern legislative intent when the question arises in the course of legal disputes, the court is guided by established rules of statutory construction. The first rule is that it's the job of the courts in interpreting law to figure out what the intent of the legislature was in passing the law. The second rule is that if the language of the law is clear and unambiguous, it states the legislature's intent, and you don't look beyond the plain language of the statute in determining, ascertaining what the intent of the legislature is. Third, if the language of the statute is ambiguous, the court then looks to extraneous sources to determine what the legislature intended in enacting ambiguous language. The first source that the courts look to is any language in the bill itself that attempts to state that intent. If there is no such language, the court then looks to legislative committee reports to determine whether those reports set out what the legislature intended. And if so, that is a record of the legislature's intent, and the court looks no further. If there is nothing of value or that's helpful in the legislative committee reports, then the courts look elsewhere. And sometimes when there's nothing else to look at, the courts will look at remarks of individual legislators on the floor during debate. That is a tertiary source of evidence of legislative intent as far as courts are concerned. Courts don't like to have to resort to remarks by individual legislators because they, on their face, they simply reflect what that one person was thinking at that moment. In this case, we have a clear, unambiguous, express statement in the bill that proposed the constitutional amendment itself as to what the legislature intended. Because it's clear and unambiguous, legislative intent is reflected in it, and I do not believe that the courts of this state will look beyond Section 1 of HB 117 in determining the legislative intent underlying the 1998 amendment.
Thank you.
Speaker.
Next up, oh, I'm sorry, Representative Hashem.
Reverend
Hashem.
Lovett, can you go up? Okay. Oh, does anybody has questions to the judge?
I have a question to the judge. Chair?
Okay, here. Let him go first because I'll ask Lovett after.
Okay, I had somebody else had a question. Representative Brower.
Thank you, Justice Levinson. And, we appreciate you and I guess your posse that made the trips to a few offices here. And I wanted to pick up on a conversation we had. Your opinion on why the federal government wouldn't be the one to decide this question for the entire country?
Well, I think the United States Supreme Court may ultimately decide the question for the entire country. It hasn't to date because it's taken the position that marriage as a subject has historically been within the jurisdiction and the prerogative of the individual states to determine. So that what the United States Supreme Court has done so far, and especially in its Windsor decision, was to make it clear that those states that gave legal recognition to same-sex marriage were entitled to deference. If the state of California or the state of Iowa or the state of Rhode Island or the state of Hawaii opens its marriage laws up to same-sex couples, the federal government may not interfere with that status and may not deny federally, legally conferred rights and benefits to couples who are married.
But generally speaking, it would be up to the state of Hawaii to define marriage, not the federal government.
I think that's true.
Okay. And you're familiar with the Bible, correct?
I think I am reasonably familiar with it.
Okay. Just getting back to maybe something a little metaphysical in the tradition of Representative Foley, it seems in the Bible there's this, what I'll call, for lack of better description, a divine law or order of a man and a woman. I mean,
well,
did God get it wrong, or what is your opinion on this? Or is my interpretation of the Bible wrong?
A friend of mine called me the other day wanting to run past a letter to the editor he was writing to the Star Advertiser on that subject to see what I thought about it. And it was a response to the suggestion that in Genesis 1, verses 27 and 28, God essentially sanctified marriage as an institution between a man and a woman, and he wanted to suggest that reasonable minds could differ on the subject. And I said to him, well, wait a minute, what does Genesis 1, 27, 28 say? And he didn't know, so I went and checked it out. And Genesis 1:27-28 is the be fruitful and multiply language or statement that is attributed to God. And I read it, and I read it, and I read it, and for the life of me, I couldn't find any reference to the matrimonial state whatsoever in it. Of course, men and women propagate. That's one of the biological functions that they're capable of discharging. But they can do it married or unmarried. And the statement itself didn't refer to marriage in the slightest.
Okay, well, thank you. It's a question for a time in the future, but Jesus had a number of things to say that may have corrected some of the Old Testament.
I'm sure he did, and I know he did, but one thing I know as well, and that is that he had nothing to say about homosexuality.
I think there's going to be a difference of opinion on that, but I'll defer to other members.
Representative Thielen next, followed by Representative Luke, represented by Representative Lowen.
Chair.
Yes. Justice Levinson, as I understand it, if I'm saying it correctly, we're dealing with a civil right. Am I correct?
If you like. I mean, I'd rather couch it in terms of us dealing with a very important right.
Then is it...
We are dealing with the civil right of marriage and whether same-sex couples should have access to it. I'm happy with that characterization.
Well, given that explanation, is it proper to put that up for a popular vote?
I don't think so, for the reason that many people have stated. The Founding Fathers and I say fathers because unfortunately, in terms of legal recognition, there weren't any founding mothers. I wish there were. But most of the original 13 colonies were unwilling to ratify the United States Constitution until a Bill of Rights was added to it. And that arose out of a fundamental distrust of central government. But one of the concerns that the proponents of a Bill of Rights were pushing or were acting out of was a fear of the tyranny of the majority. Historically, the majority has tyrannized the minority time and time and time again. And it is as American as apple pie that we do not repose the decision as to what a minority of citizens are entitled to do and not entitled to do, and in what ways they're protected and what ways they're not, to a popular vote.
Okay.
If we're dealing with rights that that fall within the rights protected by the Constitution. And here we're dealing with the question whether it is right or wrong as a policy matter to deny access to the universally recognized civil right of access to marriage to a couple otherwise eligible under state law to be married, but for the fact that they are of the same gender. That's the issue.
Okay. Thank you. Thank you, Chair.
Okay, thank you. I think next was Representative Lowen, followed by Ward.
Yes, thank you. I'm just going to go back to the discussion of the Bible we had with Representative Brower and Fale. As much as that's interesting, and
I understand. I'm very interested in the subject, but I'm not really an expert.
My question is any, as much as people want to discuss that here today, is it relevant to your decision-making process?
Not in the slightest.
And in your opinion, should it be relevant to our decision-making process?
No.
And why is that?
Because we have a separation of church and state. The religious doctrine, God's law, if you will, is very, very important. but it is an apple, and state law is an orange. And each may reflect some common values, but it would be dangerous for governmental policy to be a function of religious doctrine.
And can you explain how it would be dangerous?
Because
like maybe there's examples from the past.
It could lead to theocracy and the establishment of a state church and the persecution of dissenters. And all of that is anathema to American tradition.
Isn't that sort of one of the foundations of the creation of our nation?
It certainly is.
Thank you.
Okay, thank you very much. Next up, Representative Ward. Oh, all right. Any other members wanting to ask a question to Justice Levinson? I'm sorry. Right. Okay. There was Representative Haar and Representative Jordan. Representative Jordan, go ahead.
Yes, Chief Justice.
Oh, no, please don't.
Oh, not yet. Okay.
Don't get me in trouble.
Justice Lowenstein, thank you very much for joining us today. I'm sorry we're keeping you up there for so long and inconveniencing all our future testifiers, but this is very important. I want to go back to the Bear case. What was the Bear case evaluated on?
Are you asking Representative Jordan what was the court's legal analysis grounded in?
Sure, yes.
Okay. Well, first, the issues that were raised only under the Hawaii Constitution, not the United States Constitution. There was a due process claim raised and an equal protection claim raised. Is that what you're getting at?
No, I'm more like, did it have any decision with religious freedom or impact on that at all?
The questions of freedom of religious belief.
Did that come up in the Bear case at all?
Didn't come up in Bear at all.
So the Bear case was with what? Just the issuance of a license?
The issues were whether the due process clause of the Hawaii Constitution required giving same-sex couples access to marriage, and separately whether the state constitution's equal protection clause should give or did give same-sex couples access to the status of marriage.
Okay, so it didn't look at the First Amendment issues at all?
I'm sorry, would you repeat that?
There
was something else happening.
That's okay. Did it look at any of the First Amendment issues?
No.
It did not?
Did not.
Okay. So looking at SB 1, your thoughts, does that protect any of our religious protections?
Yes. SB 1, I'm looking at it, Section 572-E and 572-F, on its face purports to give clergy all of the religious protection that the United States Supreme Court and the United States Constitution and the Hawaii Constitution give them. They're cloaked in the mantle of the full extent of First Amendment religious freedom afforded by both the United States and state constitutions. And religious organizations are too, with the proviso that to the extent that they are also a business, and this is my paraphrase, but to the extent that they're a business, like businesses that are subject to the public accommodations law, they're subject to the same rules, only with respect to those businesses.
In your opinion, should we be looking at the Little Religious Freedom Restoration Act at all in regards to SB 1, or should that be kept off the table?
I think ideally and most cleanly one would keep the issues separate. I don't feel uncomfortable with the inclusion of sections D and E in the bill because they simply restate what our constitutions already say, and that is that people are entitled to religious freedom. And the bill doesn't erode that on its face.
So you feel if there was a challenge to that?
I would bet my house that if there were a legal challenge to the sufficiency of the protection afforded clergy, that challenge would fail. I am equally confident that a challenge to the religious exemption regarding religious organizations, regarding their businesses, if that were challenged as legally insufficient, I would be surprised beyond my ability to express it if a court were to find that protection insufficient in the bill. Now, the legislature, as a matter of policy, can erode our public accommodations law, but I hope it doesn't.
But correct me if I'm wrong, I thought in SB 1 it's only protecting the solemnization.
Right.
And ceremony.
Right.
To the extent that it's a non-profit business. I mean, a business that is not in it for a profit, correct? You have to be a non-profit. Is that what this measure is stating?
I mean, my general understanding of that provision, Representative Jordan, is that if there is a wedding chapel business that operates for the purpose of making money, that it is a place of public accommodation and it's subject to the public accommodation law. If it is Temple Emmanuel, then it doesn't fall in that category.
Okay, so SB 1 is very narrowly defined, correct?
With respect to?
The religious protection, solemnization, the marriage, and the ceremony,
well,
and the celebration.
Section E is certainly very narrowly drawn to address refusal to solemnize marriage by a clergy person, sure. Religious organizations and facilities, it says what it says.
Representative Jordan, do you mind if we go on to another questioner? I'll be happy to come back to you. But
sure. Go ahead.
Okay.
Go on.
Vice Chair Har.
Thank you. Good afternoon, Justice Levinson.
Good afternoon, Representative
Thank you.
Har.
It's been a long morning/afternoon, so thank you for your testimony and for engaging us in this line of questioning.
Thank you.
I just want to do a quick follow-up with respect to what Representative Jordan asked. So let's say Senate Bill 1 passes as is, and let's say a claim is brought, a constitutional challenge claim is brought that this bill in some way infringes or impairs the free exercise of religion. What standard would the Hawaii State Courts use in reviewing the constitutionality of that claim? What standard would be applied?
Representative Har, given that I can't think of any precedent by way of case law generated by Hawaii courts, I don't have a ready answer for you. I wish I did, but I don't.
Okay, so in light, I don't know, Justice Levinson, and I had to refresh my recollection on it as well. In light of the U.S. Supreme Court's ruling in Employment Division versus Smith, in which the court struck down, the U.S. Supreme Court did strike down the strict scrutiny test being applied to First Amendment protections.
Was that the RFRA decision?
Yes, and that's what led to RFRA. That actually led to RFRA being enacted. Sorry, for those of you in the audience, after the U.S. Supreme Court opined on the Employment Division versus Smith case. Congress then enacted the Religious Freedom Restoration Act. So I guess that's what, in light of RFRA, as well as the Supreme Court's ruling in Employment Division, what would the Hawaii Supreme Court use then? If, in the absence of any Hawaii State Court law, what would the Supreme Court look at if there was a challenge regarding the constitutionality of if there was a claim had to do with an infringement of free exercise of religion?
Representative Hart, that's a subject that I really don't feel confident expressing a professional opinion on, because my experience just isn't broad enough to do that. So I can't give you an answer that I think would be particularly helpful. I rather suspect that if I were still on the court and if the question came before me, we'd find the answer to your question, but I can't give it to you now.
Okay. And again, of course, we all look up to you as an associate justice and someone who is considered very learned in this community. So I just wanted to ensure that, I wanted to be able to ask you that question. Okay. Area number 2. You and I have gone to battle on this one, and I appreciate your explanation today. Talking about House Bill 117, I think was germane. I think it was on point, and I think you are correct. I think, and I'm going to backpedal and I'm going to apologize, because I have publicly stated that I did believe that the language was clear and unambiguous on its face. Now, getting back to what you say. So at the end of the day, the argument for you really is that the legislature has the power to define marriage, correct?
That's what the Constitution says now.
So via the constitutional amendment, it's your opinion that the people gave to the legislature the power to redefine marriage.
Correct.
Okay. So, but there's nothing to preclude the legislature from authorizing a constitutional amendment to allow the people to take away that power, correct?
Yes.
Okay, thank you very much. Thank you, Justice Levinson.
I think it would be ill-advised.
Again, that wasn't the question. Justice Levinson, that wasn't the question, but I appreciate that. Thank you very much. Thank you very much, Justice Levinson.
You're welcome.
Okay. Representative Ward, did you still have a question? Fire away.
Thank you, Chair. Just a note of reflection. This is really a historic moment having you here, Judge. This is thank you for making yourself available. The ability to or have the chance to pick the mind of a Supreme Court justice, particularly one who 20 years ago started the whole world on fire with his decision. And as a freshman at that time, I wanted to pick his brain with his, no, you can't touch with any questions a judge. And now you're here and you're open, and I got a few questions.
That was probably overly cautious, Representative Ward. I would have been happy to talk with you.
You mean I could have actually sat down with you and asked questions that now I got to wait 20 years?
Almost to your heart's content.
Oh, my goodness. Okay, number 1. And this may have come across your mind. When you did the Loving case, the historical example of the interracial marriage.
You mean when
you cited that as the core of your decision, did you have a gay gene in mind, or did you know or suspect or have that as part of your hypothesis, or did you not have that in mind?
I don't think if I understand your question, I don't think I gave
the immutable trait of race of one, the immutable trait of the other.
I had studied a lot of psychology, and I had an understanding then, and I have it now, regarding the nature-nurture issue as it relates to sexual orientation, but I guess my state of mind was the same then as it is now.
In the logic of applying the Loving case was that this gender...
my understanding on that question was unrelated to my application of the Loving decision.
Thank you. After 20 years, I finally get that answer. But now, to contemporary, fast forward to the Connecticut same-sex marriage law. Do you have, and you shouldn't necessarily be familiar, but are you familiar with the Connecticut same-sex marriage statute? And how do you see if it fits into some of the SB1 considerations that you've heard earlier today?
Some weeks ago, Representative Ward, I read the religious exemption language from the statutes of a number of the states that have recently opened marriage up to same-sex couples, I think including Connecticut. And my understanding is that those statutes contain quite a range of articulations or expressions of religious exemptions.
Did you earlier suggest that it wouldn't be prudent to exclude the churches or exempt the churches from the public accommodations law? Did I hear you correctly, or you just suggested something?
What I said, or what I meant to say, and so I'll say it again in case I misspoke. I believe that it would be unfortunate policy to undermine the state's current public accommodations law, and to the extent that commercial activity that might be undertaken by religious organizations constitutes public accommodations, I would prefer that the public accommodations law not be diluted as an accommodation to anyone, because I think it would ultimately weaken the public accommodations law, and I think that's a bad idea. But I hasten to add that that's a question of policy for this legislature to determine.
Are you quoting Judge Moon, that we have still the trump card on these things? No, that's what was earlier said in his
Well,
State
you know,
of the
the old saw that legislatures make the law always was about 80% true, and it still is.
Okay. Last question, sir. There's been a lot made of the interpretation, the intention, the con-am, the sense of where the surveys, 70% say that that belongs with the people, not the legislature, whether it's KITV or the one that family advocates had for $10,000, etc. My question is this. The people of Hawaii are not stupid. Why do you think the majority of the people have interpreted what we did in 1998 as being in favor of having marriage defined between a man and a woman? They're not stupid. I mean, did somebody create this impression in the masses of people that 70% now say, hey, we already decided on that? Why have they got that stuck in their mind if we did everything kosher and according to Hoyle, as you've just indicated to the representatives?
Well, holding the number aside, your 70% figure may be accurate or not.
Yeah, TV was 84,
I don't think we've heard from a scientific sample of people,
the $10,000 poll was scientific. I'm not asking you.
I have a sort of folksy response to that, because I think that's the best a person can do. People believe what they want to believe.
But when it's over 60%, something's going on, sir.
Right.
So I'm not asking if you want to say that people in Hawaii are stupid, but
among other
when
things,
you get that many people,
when,
something's going on about the language that they were taught or they were given the impression of that they assumed was the case. So something is amiss in terms of all the technical.
I'm not in a position to account for that any more than you or probably anybody else in this room is in a position to do it. But the fact remains that the legislature itself was clear and unambiguous with respect to its intent, and that's the intent that controls.
Again, thank you. It's historic that you're here, and I appreciate your answers.
Thank you.
Thank you, Representative Ward. I have Representative Bellotti and Representative Jordan if you have a follow-up question after that. Okay.
Thank you, Justice Levinson. To follow up on the question of my good colleague from Kapolei, we could, in fact, pass the Marriage Equality Bill, Senate Bill 1, which would then allow folks to get married. We could also pass a constitutional amendment, which may be voted on in November of next year. Wouldn't we then be in the same situation of California, where we would have a class of folks who would be married under the same-sex marriage law?
If I get your question correctly, Representative Bellotti, that's something that I've thought about a fair bit. And just as a lawyer, my sense is that if the legislature were to pass SB 1 and give legal access to same-sex couples to the status of marriage. And that access were later taken back or taken away by a constitutional amendment such as Prop 8, that Hawaii would be very similarly situated to California in the context of the issues raised by the Perry lawsuit.
And in that instance, if the constitutional amendment were struck down and there was no law in place that provided religious exemptions, then the status of the marriage law for same-sex couples would then have no religious exemptions, correct?
You're going to have to run that past me again.
I think one of the things that we're attempting to do with SB1, and I'd like to draw our attention back, of course, to SB1, is that we're trying to balance fundamental conflicts within the Constitution, equal protection under the law, and religious freedom. So if no marriage equality, or if there was no religious exemptions, and for some reason down the line, a court, whether it's a federal district court, a circuit court of appeals, or the U.S. Supreme Court, which many advocates out there believe will someday at some point in time say, because of the mass confusion in our United States, that marriage is going to be a right that is accessible to same-sex couples. If in that time, and there is no law, we don't have a state law that governs and says certain religious exemptions apply, then what will happen will be that same-sex couples will be able to have access to the marriage laws under our state that does not have any religious exemptions. Is that an accurate kind of description of what could happen?
I'm not sure. If there were no section, section 572 E and F in SB1, my suspicion is that the beneficiaries of the religious exemptions would still be entitled to the same religious freedom by virtue of constitutional protection as they are by SB1. So one way or another, I think the protection would be the same.
Thank you. And just one last question. So I guess the point that I'm trying to make is that, yes, they will have First Amendment constitutional protections, but any other greater exemptions, protections that we were trying to carve out as we are trying to do in SB1 would not be there. They would only be able to have access to the First Amendment protections.
I mean, understand, as someone who hasn't had occasion to practice in that area lately, I can't give you an encyclopedic answer, but I think the answer to your question is yes.
Go to Jordan first. Okay. Representative Jordan.
Very much, Chair. In your responses back to Representative Ward in regards to the public accommodations, did I hear you correctly that it would be wiser that the legislature should do any type of exceptions to our public accommodation rules versus the courts? Did I hear that correctly when you responded to Representative Ward?
Up to the versus the courts part, I think you heard me correctly. It's my own opinion as an individual that the legislature might come to regret any dilution of the public accommodations law that it affected for purposes of SB1, because it might come back to bite the legislature in terms of policy when it didn't intend to do that. I think the public accommodations law is a real model for the country at large, and it would be a shame to dilute it, but that's ultimately a policy determination for the legislature to make.
So you're saying maybe we shouldn't be touching that because our public accommodation law is the golden standard.
I believe that, and I think Mr. Hoshijo spoke to that subject, and he's really in a more informed position to speak to that question than I am, but I agree with him.
I wasn't quite thrilled with his response yesterday to us.
Well, I didn't hear his response, but you know, as the executive director of the Civil Rights Commission, he is thoroughly familiar with the public accommodations law, and he certainly, I think he views as part of his function protecting it to the extent that he can against dilution. And I agree as a policy matter that that's a good idea.
But he's not the final stop for that public accommodation.
No.
It would be ultimately the courts, correct?
If it came to that, yes.
Okay. So your opinion and your vast knowledge, how important is it to have the strictest scrutiny test applied to the First Amendment challenges when we're looking at these type of measures? Shouldn't we be crossing all our I's and dotting our T's back and forth? Shouldn't we? Shouldn't we be placing something very, very tight in this measure? Or should we just leave it as it is? And if it gets challenged, it'll go to Mr. Hushijo. And if that gets challenged, it goes to the courts, and then we're relying on the courts for these type of tests, especially when it comes to our public accommodations.
I think, you know, my instinct, Representative Jordan, is to defer to the legislature ultimately on that question. One can express policy preferences to you, but what you do with the public accommodations law is ultimately your call.
At the end of the day, it should be us then.
At the end of the day, it is you.
Okay.
And, you know, if what you do is legally defective, and I don't know whether it would be or not, but if it were subject to a meritorious legal challenge, then I presume that could happen, and then the courts would decide. But I speak totally hypothetically because I don't have a controversy in mind.
Thank you very much.
Thank you.
And thank you for being here.
Thank you. Representative Har, followed by Representative Ng. Okay, Representative Ng.
Thank you, Chair, and thank you, Justice, for taking the time. I don't want to harp on this point. I know you've been up here for a while, but there's been a lot of discussion about how this bill goes beyond marriage, and it establishes a sort of law of the land which departments must adhere to. I know a colleague of mine mentioned that. So I was wondering if there's any law of the land greater than the laws we make here in the Capitol.
I'm sorry, I just don't understand.
Is there, well, yeah, it's a little nebulous, the idea of the law of the land. It's a little kind of a vague statement. But is there any higher authority of law, perhaps like the U.S. Constitution? Is that the ultimate law of the land?
Well, the United States Supreme Court has a supremacy clause, which generally means that when federal and state law conflict, federal law controls. Certainly when federal law that deals with individual rights is more protective than state law, federal law controls. State law is free to be more protective than federal law, I should add.
There's been some concern, I guess, among the public that certain First Amendment rights in the U.S. Constitution will be infringed upon if this law does pass. Is that possible?
Well, as the man said, anything's possible. But
have any laws that we've...
But as a general proposition, you know, you could say with a lot of confidence that if state law fails to satisfy the First Amendment, then state law is defective.
Right, and has that happened in the past? Have we made a law in the state that's been shut down by the U.S.
I'm not aware of that happening in Hawaii.
But has it happened in other states, or just, is that possible?
Oh, it's certainly possible.
So anything we do here, any law we make will be trumped by law, especially the U.S. Constitution, and the First Amendment rights will still be established, essentially.
No matter, you know, you can't run and hide from the United States Constitution. If the state takes action and acts law that violates the United States Constitution, then that state law is not long for this world.
Okay, so it's my understanding that the ultimate law of the land is the U.S. Constitution.
Well,
is that fair?
I think as you mean it, yes, but it's not quite that simple.
All right, thank you.
Thank you. Representative Har.
Thank you, Madam Chair. Justice Levinson, I just want to follow up on some of the line of questioning from my good colleague from Makiki. Okay, she talked about the Perry case, and I do agree with you that, and I think the three of us can probably agree that to some extent the Ninth Circuit, it was clear that the Ninth Circuit made clear that once a right, such as same-sex marriage, after that first license is issued, that right somewhat becomes vested. And at that point, once it becomes vested, you cannot then take that right away. Is that a fair assessment?
Using the term vested in a very broad sense.
I agree. Without having the opinion in front of me,
I think
agree.
we're thinking along the same
Yes.
lines.
Okay, thank you. Thank you, Justice. That's a huge compliment coming from you. So that being said, I think the line of questioning asked by my colleague was, if we in fact passed a constitutional amendment allowing the people to take away our legislative authority and subsequently allowing the people then to vote on the issue of same-sex marriage and concurrently allowing Senate Bill 1 to pass, then obviously we would be in a situation where we would not be able, the subsequent Con Am would be a problem. Isn't that correct?
Well, it would certainly distinguish our situation from California.
Right. But again, I mean, I think that's probably one of the reasons why people are asking the legislature to take pause, because maybe some people understand the ramifications. And, granted, the fact of the matter is the Supreme Court vacated the Ninth Circuit's ruling. So, I'm still
interestingly enough, therefore defaulted the judgment back to the federal district court, Judge Walker, and the parameters of his decision were, of course, much broader than the Ninth Circuit.
Yes. Yes. So, okay, that being said, moving on. And then the second thing I want to bring up.
I'm going to stop it just for a sec. I want to see if Michelle Takayo is still here. She has a 2:40 flight, and we weren't anticipating the questioning of Justice Levinson to go this long. So if I could if with the audience and the members' indulgence, if we could accommodate Ms. Takayo to catch her 2:40 flight, which is pretty close now. So Justice Levinson, with your indulgence, if you could stick around a little bit more so that we can accommodate this person.
Sure. Thank you, Madam Chair.
If that's okay.
Aloha, Representatives. My name is Michelle Tenkayo. My number is 3907. I'm here from Molokai. I remember about 20 years ago, I brought my two young sons here.
If the audience could quiet down a little bit. Thank you.
About 20 years ago, I remember first coming here with my two young sons to hold signs against same-sex marriage, and I find myself here again today. And I understand this special session is not something that you've instituted, but is in response to what the governor has put into motion. My family's roots run deep in the islands, very deep. Over the last 2 days, I stood by people who stand in line who are...
Because they're going to amend the bill. And either we got to agree or we would have...
Chair, could she start over, please, with a better mic?
I think there's a microphone outside. Okay, recess real short.
He took my bill.
Somebody take the mic. Anymore. Thank you. Please proceed.
Okay. As I was saying, it's been 20 years since I've returned here on this same issue. I firmly believe that the legislature should not be willing to make such a crucial decision on this divisive matter without letting the people decide again. But obviously, it seems like it's not leaning towards letting the people decide. So I'm asking you then to take into consideration the state's motto, the life of this land is perpetuated in righteousness. And I'm leaving it up to you to decide what righteousness means. Obviously, the majority of the people of this state is opposed to same-sex marriage. Why are we in a rush to become the 15th state to okay this? This is too short, this is too fast, this is too much unanswered questions, and we've already voted on this matter before. If people are so intent on changing the definition of marriage to suit their needs to have so-called civil rights and those things afforded them, then go find it in another state. The majority of the people of this state is saying no, not here and not today. And I'm asking you to vote no on SB 1 if you're not going to let the people decide. Thank you.
Can we have Justice Levinson come back? And thank you so much for your patience. Let me see. We'll wait for Vice Chair Har, but in the meantime, Representative Kobayashi, you can continue your questioning.
Justice Levinson, I'd like to get back to a question put to you by Representative Bellotti and Representative Har regarding what we have heard a great deal today and yesterday, meaning let the people decide. In California, Proposition 8 was passed, and Proposition 8 said in simple terms what some of the people here in this room would like to see put to the ballot. That is, Proposition 8 said fairly simply and directly, only marriage between a man and a woman is valid or recognized in California. Now, eventually, it seems that the voice of the people of California, the most populous state in the country, was overridden, at least in part, by the recent U.S. Supreme Court case in June. Now, I thought I heard you say to Representative Har that should Hawaii pass a constitutional amendment similar to California, that is, in pretty clear terms, only marriage between a man and a woman is valid or recognized in Hawaii, that there is a likelihood, and I didn't get at what level of likelihood, that Hawaii, that new Hawaii constitutional amendment might be overridden in the court system. Is that correct?
Let me try to repeat or paraphrase what I said to Representative Har in response to her question. If the legislature were to pass SB 1 as is or somewhat amended, but essentially retaining the primary result of the bill, eliminating the couple of partners of opposite sex eligibility requirement, and the legislature were, and after that, same-sex couples were to have marriages solemnized in Hawaii, and after that, the state constitution were amended a la Prop 8, or some other states like Texas and Ohio that have essentially enshrine provisions in their constitutions that say same-sex marriage or any status that walks, talks, or quacks like it, and that would include civil union, is forbidden in this jurisdiction, and that constitutional amendment were later challenged in a lawsuit as Prop 8 was in California. I thought that Hawaii would be in a position very similarly situated to California's position. It would have afforded access to marriage to same-sex couples. It then would have taken that access away. And according to the analysis of the Ninth Circuit Court of Appeals, that would constitute a violation of the federal rights of equal protection and due process.
So my question is, what level of confidence do you have that that might occur? Earlier you said on another question that you would be willing to bet your house that a certain thing might happen. Would you bet half a house, a third of a house? I mean, high, medium, and low?
Oh, I'd
How
probably
confident would you be that if Hawaii were to pass a constitutional amendment saying that only marriage between a man and a woman is valid or recognized in Hawaii, that we would end up in a similar situation?
SB 1?
Yes. That we would be in a similar situation to California's Proposition 8.
Well, let me put it this way. The question would ultimately go to the Ninth Circuit Court of Appeals, because Hawaii is part of the Ninth Circuit, just as California is. And unless the Ninth Circuit switched its analysis, I don't see how the court could distinguish between Hawaii and California.
Sure.
Okay, are you done, Representative Kobayashi? Okay, Representative Ward.
Just a follow-up to that, Judge. Is it accurate to say that the Prop 8 decision was overridden, or that there was a lack of standing on the party who brought the suit?
Well,
because he said it was overridden, and that gives the impression that if you have the vote of the people, that it's going to be overridden by the Supreme Court, where it said you in the state of California who brought this suit, those who did all the lobbying, etc., were given no standing, even though the Supreme Court of California gave standing to those individuals. The U.S. Supreme Court did not give them standing. Therefore, the court was essentially tossing it out. Saying it's overridden is a different proposition. Is that not correct?
You're raising a few questions, Representative Ward. Let me try to answer them all. At the Federal Circuit Court of Appeals level, the Perry lawsuit was considered by the Ninth Circuit. The Ninth Circuit affirmed the Federal District Court in San Francisco.
That Prop 8 was okay?
No, quite the opposite.
Okay. You have to use street language.
On the base, Judge Walker in the United States District Court for the Central District of California struck down Prop 8 on very broad grounds. The proponents of Prop 8 appealed to the Ninth Circuit. The Ninth Circuit held that Judge Walker had been correct in his bottom line, but the Ninth Circuit narrowed the grounds that Judge Walker had expressed in striking Prop 8 down. So what the Ninth Circuit said was, here we have a case in which the California
Human Services, Adult Protective and Community.
Was that God?
Or the NSA?
Okay.
The Ninth Circuit said,
Okay,
here we have a
Justice
situation in
Levinson,
which
hold on just a sec. If I could ask the members of Acknowledgence to wrap up their questions because we have a bunch of people that we were planning to take next to, so that they could make their flights. So
He's climbing up to the Supreme Court because that's really where my question was, at the Supreme Court level. What did they say?
What the Supreme Court did with the Ninth Circuit's judgment was to say, well, wait a minute, we agree that the people who originally proposed Prop 8 really didn't have standing
There you go.
to appeal either to the Ninth Circuit or to this court. It never should have gone that. It never should have left the federal district court. So we are dismissing the appeal to the United States Supreme Court. We are vacating the judgment of the Ninth Circuit. And so the effect of that was to default back to the original judgment of the federal district court, Judge Walker, who struck Prop 8 down on even broader grounds than the Ninth Circuit did.
Okay. Thank you for that chronology.
Thank you,
Chair.
Any other questions? I know Representative Hashem had a question for one of the persons in the grouping.
Okay, Reverend,